Saturday, day 3 of the Melania Trump asset seizure. Judge Kaplan just issued final order making seizures permanent. Filed 7:14 a.m. this morning. $32.8 million in assets. No return, no appeal granted. 3 days, 9 separate filings. Here's where we are. Melania's Palm Beach property seized Thursday. Emergency stay denied Friday. Permanent seizure order issued today. Today changed everything about spousal asset protection. Judge Kaplan ruled marital property transfer doesn't shield assets from judgment enforcement. But most coverage is missing the full legal picture. I'm going to show you the complete timeline where this started Thursday, where the emergency motions failed Friday, where the permanent order stands today. 3 tracks, all moving, all connected. By the end, you'll see why this isn't just about one property. It's about whether marriage protects assets from judgment. Let's map this out. Current situation. Melania Trump lost all 3 emergency challenges. $32.8 million in assets now permanently assigned to Carroll Judgment Enforcement. No further appeal options granted. Issued final order this morning. Rejected spousal immunity arguments. Authorized immediate liquidation proceedings. Eugene Carroll's legal team can now begin sale process. Full enforcement authority granted. Priority creditor status confirmed. Active proceedings. Federal judgment enforcement. Carroll vs. Trump. Original case. Melania's separate constitutional challenge. Spousal rights case. Asset liquidation process. Property sales track. Immediate pressure points. Monday 9 a.m. first auction scheduled. West Palm Beach condo portfolio. Wednesday, Melania's constitutional appeal due to Second Circuit. That's the snapshot. Now, let me show you how 3 days turned a Carroll judgment against Donald Trump into permanent seizure of Melania's assets. The beginning. March 2024. Carroll wins $83.3 million defamation judgment against Donald Trump. Trump's attorney predicted, if he doesn't pay, they'll come after everything, including marital assets. What happened? Trump exhausted appeals. Denied. March 2026. Judgment became enforceable April 1, 2026. Trump transferred properties to Melania April 15 through 22, 2026. Each time, Carroll's attorneys documented the transfers in real time. Background. April 2026. Carroll's legal team filed enforcement action identifying $127 million in assets transferred to Melania during appeal period. Textbook fraudulent conveyance to avoid judgment enforcement. Court response. Kaplan ordered asset freeze. April 28. Hearing scheduled for June. Trump legal team claims spousal immunity. Then everything accelerated. Day 1, Thursday, May 7. 7:23 a.m. Judge Kaplan issues emergency seizure order, $32.88 million in immediately identifiable Melania titled assets frozen and reassigned to Carroll judgment. Transfers made with intent to hinder collection constitute fraud regardless of marital relationship. Immediate reaction. Melania's lawyers file emergency stay motion. Trump lawyers file separate joiner 4 hours. That's how fast emergency response came. What most people missed, Kaplan's order specifically referenced bank records subpoenaed April 30. He already had evidence of transfer timing when he issued seizure. Day 2, Friday, May 8. 2:34 p.m. Kaplan denies emergency stay, 8-page order. This changed the timeline from temporary freeze pending hearing to seizure stands unless overturned on appeal. Kaplan's reasoning. Spousal transfer after judgment entered cannot defeat creditor rights under New York fraudulent conveyance law. New players entered. Second Circuit expedited briefing schedule. Melania's appeal. Property liquidation firm engaged by Carroll's attorneys. 4 banks notified of account assignment. The story split into multiple tracks. Active seizure plus constitutional appeal plus liquidation process. Day 3, Saturday, May 9. Today, 7:14 a.m. Kaplan issues final order making seizures permanent. Authorizes immediate liquidation. This is where we are now. The pattern. Each day, Melania's team tried different legal theory to stop enforcement. Each day, Kaplan rejected spousal immunity arguments and tightened enforcement authority. 3 days emergency freeze became permanent seizure with liquidation authority. The original strategy claim marital property protection failed completely against documented fraudulent transfer evidence. Subscribe. This timeline is expanding into constitutional territory, and 3 more Trump family members just received similar asset identification notices. Yesterday's key development: Judge Kaplan denied Melania's emergency stay motion with 8-page written opinion. Why it mattered: established legal standard. Spousal transfers after judgment can't shield assets applies beyond just this case. Eliminated delay tactic. Stay denial meant no waiting for full appeal. Enforcement proceeds immediately. What it set up forced Melania's team to either accept permanent loss or file constitutional appeal with no enforcement pause. Specific example: before yesterday, Melania could argue emergency stay should preserve status quo during appeal. After yesterday, Kaplan ruled status quo is judgment creditor enforcement, not transferred asset protection. That shift enabled today's permanent order. Kaplan had already decided core legal question yesterday. Today, just formalized procedures. Kaplan's analysis yesterday. New York Debtor and Creditor Law Section 276 governs fraudulent conveyance. Transfer timing April 15 through 22 after appeal denial March 28 establishes intent. Marital relationship doesn't create exception to fraudulent conveyance law. Constitutional spousal rights arguments belong in appeal, not emergency stay. All 4 points rejected Melania's legal theories. Today's order simply applied yesterday's reasoning to make seizures permanent and authorized liquidation. The key language yesterday: no likelihood of success on the merits. That's legal terminology, meaning Kaplan thinks Melania's appeal will fail. When the judge says that, denying emergency stay, permanent enforcement becomes inevitable. Melania's attorneys knew yesterday afternoon. That's why no additional filings came last night. Yesterday's decision is when this became irreversible without successful appeal. Today's development: Judge Kaplan issued final permanence order authorizing immediate asset liquidation. 7:14 a.m. 12 pages complete enforcement authority granted to Carol's attorneys. Why this is different from Day 1 and Day 2. Day 1, emergency seizure. Assets frozen but not yet disposable. Day 2, stay denied. Seizure stands but liquidation not yet authorized. Today, permanent assignment plus liquidation authority. Carol's team can now sell everything. 3 specific changes. Change 1. Before today, assets were frozen but couldn't be sold pending legal resolution. After today, Carol's attorneys have authorization to begin auction process Monday Mo. Change 2. Before today, Melania retained theoretical ownership if appeal succeeded. After today, legal title transferred to Carol judgment enforcement. Melania is no longer owner on paper. Change 3. Before today, this was seizure subject to constitutional challenge. After today, this is completed transfer. Constitutional appeal now seeks compensation, not return of property. The cumulative effect. 3 days ago, Melania owned $32.8 million in assets that Carol's team wanted to seize. 2 days ago, assets were frozen, but ownership disputed. Today, Carol's team owns the assets legally and can convert to cash. Each day move from attempted enforcement to completed enforcement. Today crossed the finality threshold. The practical impact: Monday 9 a.m. West Palm Beach condo portfolio goes to auction. That's 72 hours from today's order to cash proceeds. Kaplan's order specifically authorizes expedited sale procedures without standard 30-day notice periods. Why? Judgment DTOR's fraudulent transfer history demonstrates flight risk for additional asset dissipation. Translation: Kaplan thinks Trump family will hide more assets if given time. So, his authorizing speed enforcement. Today's order isn't just permanent seizure, it's fast-track liquidation. Before this was frozen assets, today this is assets being sold this week. See how each day built on the last. Like this if you're following the legal progression. Next week gets more complex. This isn't one story anymore. It's three. Track 1. Carroll Judgment Enforcement. Status. Enforcement proceeding against Melania's assets. $32.8 million liquidation authorized. Monday auction scheduled. Key date, Monday, May 11th, 9 a.m. First asset auction, West Palm condo portfolio, estimated $8.2 million. What happens if auction succeeds? Establishes precedent that seized Trump family assets can be quickly converted to cash. Applies to $94 million in additional identified assets. Track 2. Melania's constitutional appeal. Status. Second Circuit expedited briefing. Opening brief due Wednesday, May 14th. Key date, Wednesday, May 14th. Melania's constitutional brief deadline. Arguments will center on spousal property rights and Fifth Amendment due process. What happens if Second Circuit grants stay? Liquidation pauses, but odds low given Kaplan's no likelihood of success finding. If denied, constitutional arguments move to full appeal while liquidation proceeds. Track 3. Additional Trump family asset identification. Status. Carroll's attorneys filed supplemental asset identification Thursday targeting Eric Trump, Donald Trump Jr., and Ivanka Trump properties. Key date, May 19th. Kaplan hearing on expanding enforcement to adult children's assets received 2023-2024. What happens if Kaplan applies same fraudulent conveyance analysis to adult children? Enforcement expands from $32.8 million to potentially $127 million in all identified transferred assets. How they connect. Track 1 outcome affects Track 3 because successful Monday auction proves liquidation process works gives Kaplan confidence authorizing broader seizures. Track 2 outcome affects Track 1 because successful stay would pause liquidation but also affects Track 3 because same constitutional arguments would apply to adult children. They're not separate, they're synchronized. If Track 1 moves first, Monday auction succeeds. Tracks 2 and 3 face accomplish fact. Harder to reverse completed sales than prevent future seizures. If Track 2 moves first, Wednesday stay granted. Track 1 pauses and Track 3 expansion unlikely until appeal resolves. Who matters at this point? Melania Trump position lost ownership of $32.88 million in assets. Constitutional appeal pending. No enforcement pause granted. Strategy. Appeal on constitutional grounds while attempting to slow liquidation through procedural motions. Power. None over Track 1 enforcement. Limited to appellate arguments on Track 2. Kaplan controls everything. Judge Lewis Kaplan. Position. Federal judge with complete enforcement authority has ruled on fraudulent conveyance issue authorized expedited liquidation strategy. Fast-track asset conversion to prevent additional Trump family transfers. Reject delay tactics. Establish precedent for Track 3 expansion. Power can authorize all seizures. Set sale procedures. Expand enforcement to other family members. His orders are immediately enforceable. Robera Kaplan, Carroll's attorney. Position represents judgment creditor. Has liquidation authority coordinating Monday auction pursuing $94 million additional assets. Strategy. Convert Melania assets to cash fast. Use success to justify Track 3 expansion. Establish that Trump family assets are reachable. Power controls liquidation process can bid at auctions to ensure minimum recovery drives enforcement timeline. In Carroll position judgment creditor owed $83.3 million has priority claim on all seized assets first $32.8 million coming this month. Power, legal owner of enforcement rights, can approve settlement offers, controls whether to pursue additional family members. Who dropped out? Donald Trump's attorneys tried to intervene day 1 to 2, but Kaplan ruled Trump isn't party to Melania's ownership claims. Can't defend her property. The power dynamic shifted from Melania controlling her assets to Kaplan controlling liquidation timeline to Carroll's attorneys controlling actual sales. This is complex. 3 separate tracks all moving simultaneously. Stay with me. The constitutional implications get clearer in the next section. Why 3 days matters. Spousal asset transfers can no longer shield property from judgment enforcement when transfers occur after judgment entered. The precedent before this week. Judgment debtor transfers assets to spouse. Complicated legal battle. Years of litigation. Often successful delay after this week. Judgment debtor transfers assets to spouse after judgment. Fraudulent conveyance analysis. Immediate seizure. Fast liquidation. Concrete example. You win lawsuit against someone. They transfer house to spouse. You want to collect. Before you'd file fraudulent conveyance case, wait for trial, prove intent, fight spousal immunity arguments. 2 to 3 years minimum. After if transfer happened after your judgment, Kaplan's precedent allows emergency seizure. Burden shifts to spouse to prove legitimate transfer. Liquidation proceeds during appeal. 3 days created fast-track enforcement against spousal transfers. Why this matters beyond Trump. Every judgment creditor can now cite Kaplan's Melania order for expedited spousal asset seizure. Every judgment debtor knows spousal transfers won't work as delay tactic. The math changed before. Transfer to spouse equals 2 to 3 years protection while litigating. After transfer to spouse after judgment equals immediate seizure plus burden to prove legitimacy. Kaplan didn't just enforce Carroll's judgment. He created precedent that makes post-judgment family transfers ineffective. The practical effect. Wealthy defendants can no longer use family members as asset shields after losing cases. 3 days ended decades of judgment avoidance strategy. 3 moments that mattered most. Moment 1. Kaplan's emergency seizure order. Thursday 7:23 a.m. when day 1 Thursday morning before Melania's attorneys could file protective motions. What happened? Kaplan issued seizure based on bank records showing April 15 through 22 transfers gave Melania's team no advance warning. Why it was critical. This eliminated Melania's ability to further transfer or encumber assets before enforcement began. If this hadn't happened, Melania's attorneys would have filed protective motions first, arguing for slower process, could have delayed weeks or months. Moment 2. Stay denial with no likelihood of success language. Friday 2:34 p.m. When day 2, Friday afternoon, after full day of emergency briefing, what happened? Kaplan not only denied stay but explicitly stated Melania's constitutional arguments unlikely to succeed on appeal. Why it was critical. This signaled to Second Circuit that district judge sees no merit in appeal makes appellate stay extremely unlikely. If this hadn't happened, Melania could argue the Second Circuit that district judge hadn't evaluated merits might have gotten appellate stay pending full review. Moment 3. Liquidation authorization in final order. Today, 7:14 a.m. When? Day 3, Saturday morning. Weekend filing showing urgency. What happened? Kaplan authorized immediate sales without standard notice periods, explicitly citing flight risk. Why it was critical. This compressed timeline from months-long liquidation to days-long auctions. Monday sale means cash recovery this week. If this hadn't happened, standard procedures would allow 30-day notice, giving Melania time for additional appeals. Those 3 moments determined everything that followed. Moment 1 secured the assets. Moment 2 eliminated stay options. Moment 3 enabled fast conversion to cash. Together 3 days from seizure to liquidation instead of typical 6 to 12 months. Kaplan controlled timing at every step. Like if this timeline breakdown is making the legal strategy clear, Kaplan's timing was deliberate. What happens over the next week? Monday, May 11th, 9 a.m. First auction. West Palm Beach condo portfolio. 6 units, estimated $8.2 million value. Likely outcome. Carroll's legal team bids floor price to ensure sale. Units sell for 70 to 85% of market value. 6 to 7 million cash proceeds by end of week. Alternative. Melania gets emergency appellate stay Sunday night. Monday auction cancelled. Extremely unlikely giving Kaplan's Friday no likelihood of success language. Tuesday, May 12th, second auction, art collection and jewelry. $4.1 million appraised value. Likely outcome, Luxury asset sales typically yield 50 to 60% of appraisal in 4 sales. Expect $2 to $2.5 million proceeds. This determines whether Kaplan's expedited timeline works for non-real estate assets. If successful, validates approach for remaining $20 million. Wednesday, May 14th. 2 major events. Melania's constitutional brief due to Second Circuit 2 p.m. deadline and third auction Florida Keys property $3.8 million. These connect because brief will argue liquidation during appeal violates due process. But if Monday, Tuesday sales already completed becomes argument about compensation, not return of property. Thursday, Friday, May 15th through 16th, Carroll's attorneys respond to constitutional brief. Thursday, Kaplan hearing on expanding enforcement to trump adult children's assets moved to Monday, May 19th. How they relate. Carroll's response will cite successful liquidations as proof process works and should expand to additional $94 million in identified assets. Saturday, Sunday, May 17th through 18th, Second Circuit Emergency Panel Review Period. 3 possible outcomes. 1. Stay granted, 5% probability. Liquidation pauses, remaining $23 million protected. 2. Stay denied, 85% probability. Liquidation continues. Constitutional arguments proceed on normal timeline. 3. Partial stay, 10% probability. Completed sales stand, future sales pause. By next Saturday, May 17th, we'll know whether Kaplan's fast-track liquidation successfully converted assets to cash. Whether Second Circuit granted any appellate relief to Melania, whether Track 3 expansion to adult children will proceed. May 19th. The pattern suggests Kaplan's timeline holds. 3 days showed his controlling pace, rejecting delays, moving faster than typical enforcement. Most likely 10 to 12 million in Carroll's hands by next Saturday. Constitutional appeal proceeds without stay. Track 3 expansion authorized May 19th. Subscribe. Next 7 days determine whether $32.8 million becomes $127 million enforcement and whether Trump family asset protection strategy survives. Complete current state legal status. Track $132.8 million seized. Liquidation authorized. Monday 9 a.m. First auction scheduled. Track 2, appeal briefing proceeding. Wednesday deadline, no stay granted. May 19th, hearing on adult children's assets, $94 million. Additional exposure. Key players' positions. Melania, no ownership of seized assets. Constitutional appeal pending. Liquidation proceeding regardless. Kaplan, full enforcement authority, authorized expedited sales. May 19th expansion hearing scheduled. Carroll's attorneys control liquidation coordinate auctions seeking Track 3 expansion. Trump family 3 adult children facing similar asset identification. Separate counsel retained. Locked variables. $32.8 million seizure is final. Fraudulent conveyance finding is established. Liquidation authority granted. Monday auction will occur. Open variables. Whether Second Circuit grants stay, whether Monday, Wednesday auctions yield expected 10 to 12 million, whether May 19th hearing expands enforcement to adult children, whether constitutional appeal ultimately succeeds. Timeline trajectory. Day 1. Kaplan seized assets using bank records showing April transfers. Day 2. Kaplan denied stay, ruled no likelihood of success on constitutional claims. Day 3. Kaplan authorized expedited liquidation. Sales begin Monday. Pattern accelerating toward rapid cash conversion. Kaplan compressed typical 6 to 12-month enforcement into 1-week liquidation. Each day eliminated delay option and tightened timeline. Next inflection point. Monday 9 a.m. auction. If successful, validates expedited approach. Expansion to Track 3 likely. If Second Circuit intervenes Sunday, everything pauses, but constitutional merit still weak. 5 things to track. 1. Sunday night, May 10th. If Second Circuit stay granted, Monday auction cancelled. Everything pauses. If no stay by midnight, Monday auction proceeds as scheduled. 2. Monday auction results. Watch for final sale prices versus appraised values tells us whether expedited process yields are reasonable recovery or fire sale losses. 3. Wednesday constitutional brief could change everything if Melania's attorney's present novel due process argument Second Circuit finds compelling. Unlikely but possible stay granted midweek after briefing review. 4. 3-day pattern continuation. If May 19 hearing expands enforcement like days 1 through 3 accelerated, Track 3 brings $94 million more assets into play. If pattern breaks, Kaplan slows down suggests he sees constitutional concerns. 5. The question ultimately, can spouses shield assets from judgments through marital transfers? Monday's auction starts answering it with actual cash recovery. I'll be covering Monday's auction results and any Second Circuit emergency orders. Complete enforcement update after first week of liquidation concludes.